have a quorum yet, and so we're going to start as a subcommittee. Mr. Lowenthal, you are the author. Mr. Lowenthal,
Not ready.
are you ready to present? As we begin, I want to remind everyone that our general rule is that we want to give everyone an opportunity to speak, and generally we allow 2 witnesses each for support and 2 witnesses for opposition, limited to 2 minutes each. Then others, as they stand up, please state your name and affiliation. Welcome. You may begin. Is that on? Try it now.
All right. SB 341 simply requires that commercial vehicles with a gross vehicle weight of over 14,000 pounds that transport construction or industrial materials to and from a construction site or to a mine site be equipped with an automatic backup alarm. Already, state and federal occupational safety law requires backup alarms at aggregate and construction sites. Unfortunately, in our vehicle code, there's no such requirement, which leads to inconsistencies and confusions. These alarms are not very expensive. They save lives. This is one of the leading causes of lives. It is all, we're just trying to make state law, vehicle code consistent with occupational safety law. It's a bipartisan measure, has no opposition. We will work to make sure that the definition is tightened enough as we move through, that we do not exempt those that shouldn't be exempt, and that we identify those that really need to be. There's been some questions of tightening it up somewhat, and we're certainly amenable to do that. And with that, I urge an aye vote, and I have witnesses in support.
Witnesses in support.
Charlie Ray with CalSEMA sponsored the bill, and again, this helps close the gap in safety law, and we appreciate your support. Thank you.
Thank you. Other witnesses in support?
I'm Mike Hurgis. I'm the safety manager for Granite Rock and the chair of CalSEMA's Health and Safety Committee. It was just a little over 5 years ago, last Wednesday, that we lost a member of Granite Rock who was fatally injured when a semi end dump backed into this individual who was cleaning the spray bar on his roller. The truck that caused the fatal injuries did not have a working backup alarm on it. We do the best we can with ensuring that this is, but we believe that this bill would help close the gap, as has been said, to provide an extra level of protection for our people. Respectfully ask for your vote on this bill. Thank you.
Thank you. Other witnesses in support?
My name is Mark Longpre. I work with A. Dykert & Son. I'm a field environmental and safety specialist for them. I can't follow back after Mike's comment, except to say it ties in an industrial safety rule with the current vehicular code, and it's a good way of helping to ensure the safety of people on the ground, either at the job site or at the fixed plant sites, that we do have backup alarms at work.
Thank you, Madam Chair. Members, Brooks Ellison on behalf of the California Dump Truck Owners Association in support.
And Madam Chair, Dave Ackerman representing the Associated General Contractors in support.
Thank you. Are there other witnesses in support? Witnesses in opposition? Mr. Lowenthal, before you close, we do have a quorum. I'm going to take the roll.
Lowenthal?
Here.
Jeffries?
Here.
Ashajian? Blumenfield? Here. Bonilla? Here. Buchanan? Ing?
Here.
Furtani?
Here. Yes.
Gaggiani? Yes. Logue? Miller? Here. Norby? Here. Portantino? Solorio? We have a quorum.
We have a quorum, and we have 2 items on the consent calendar. If we could vote on that now. Item 5, Senate Bill 290 by Correa, and item 6, Senate Bill 791 by Mr. Steinberg. Could you call the roll on that, please?
Lowenthal.
Aye.
Lowenthal, aye. Jeffries.
Aye.
Jeffries, aye. Ashajian. Aye. Ashajian, aye. Blumenfield. Aye. Blumenfield, aye. Benia. Benia, aye. Buchanan. Ing. Ing, aye. Furtani. Furtani, aye. Galgiani. Galgiani, aye. Logue. Miller. Miller, aye. Norby. Norby, aye. Portantino. Florio. 10-0. the bill's
10-0. Consent measures are out. Mr. Lowenthal, would you like to close?
Just to urge you, I vote, and say a beep in time will save a life.
Right. Thank you very much. It's very straightforward safety measure, and I'm certainly going to support it. And I don't see any other comments. There was a motion by Mr. Furutani, was it, or Mr. Eng? Eng, by Mr. Eng. Could you call the roll, please?
Lowenthal.
Aye.
Lowenthal, aye. Jeffries.
Aye.
Jeffries, aye. Ashajian.
Aye.
Ashajian, aye. Blumenfield. Blumenfield, aye. Bonilla. Bonilla, aye. Buchanan. Ing. Ing, aye. Furtani. Furtani, aye. Galgiani. Galgiani, aye. Logue. Miller. Miller, aye. Norby. Norby, aye. Portantino. Solorio. 10-0.
10-0. Your bill is out.
Thank you.
Mr. Simidian. Which one is this? Mr. Simidian, are you going to start on SB 28?
Your pleasure, Madam Chair.
Please.
Thank you. Madam Chair, actually, I have 2 bills before your committee today, SB 28 and SB 29. They are both in, I believe, relatively good shape because they both got the chair's special treatment last year when I had these bills before you. In all seriousness, you and your staff spent quite a bit of time working through the last outstanding issues we had last year. Both of these bills got out of your committee. The amendments were then pending, so it wasn't quite as clear as it is today. Today we have the real product before you. They both were held in suspense last year in the Assembly Appropriations Committee, and we're back again this year. The first bill up before you is SB 28. This is a follow-up on the cell phone safety legislation that I authored in 2006, took effect in 2008, and essentially there's a good news, bad news story. The good news is that in the year immediately following the implementation of our hands-free cell phone bill here in California, July 1st, 2008 to July 1st, 2009, we saw really remarkable results. Fatalities dropped by 20% here in California in the immediate aftermath of the new law. That was 700 fewer fatalities in the year following the implementation of the new law on either an annual average over the preceding 3 or 5 years. We double-checked to make sure it wasn't just a blip in a particular period of time. Similarly good results on collisions. There were 20% fewer collisions on an annualized basis in the first year of the new law compared to the annual average over the preceding 3 or 5 years. And that's 75,000 to 100,000 fewer collisions each year, members. So really a very good result and consistent with some research that Public Policy Institute of California had done. So what's the bad news if that's the good news? The bad news is that compliance is still probably only at about 60 to 70% based on the information we have both from AAA and from the state's own Office of Traffic Safety. So the good news is really an extraordinary result. The decrease in collisions was the single greatest year-to-year decrease that we had seen in the 20 years for which we have CHP data. But with 60 to 70% compliance, we could do better. The CHP tells us that the keys to better compliance are having a more significant deterrent on the books, having a better public education effort in place, and increasing enforcement. The fine originally, the base fine was $20, a very modest base fine. The typical base fine, members, for a vehicle code violation is $100. So if you are in the carpool lane when you shouldn't be, $100 base fine. If you are littering out there on the highway, $100 base fine. If you are riding in the trunk of your car when you shouldn't be, $100 base fine. I do not want to go that high with all the additional fees and penalties. It gets pretty expensive. So what we've done is we've said, how about $50 for the base fine? That will give us a more significant deterrent. And we've used $10 of that additional $30 increment for a public awareness program to be run by our Office of Traffic Safety. So we're going to try and take the very fine money that might be achieved and turn it around and put it back into public awareness and hopefully reduce the number of violations over time. We believe that if we do those things over time, we can save even more lives, avoid even more collisions. The big issue you'll recall, Madam Chair and members who are returning, last year was that there was a point on the driver's license for a first offense. That struck some people as a little heavy. We compromised with a point for a second or subsequent offense, and with that amendment, opposition that previously existed disappeared. So I think we're in good shape today. If you look at the list of supporters, you'll see that we have support from the wireless industry in the form of Verizon Wireless, support from law enforcement in the form of the California Highway Patrol Association, support from motorists and cyclists, both AAA Northern California as well as the Bicycle Coalition for California are all in support, and I would respectfully ask for an aye vote.
Move the bill.
We do have witnesses, Madam
There's
Chair.
a motion. There's a motion and a second. I know you have witnesses here. Generally, we ask for 2 minutes each for support, 2 for opposition, but I know we also have a mom here whose son passed away in an accident when a driver was using a cell phone.
I'm trying to quickly slash this to make it shorter.
We'd like to hear from you, though.
Thank you. My name is Eileen Okerblom, and I live on the Central Coast. I'm here today to put a face and a story to the meaning of Senate Bill 28. My 19-year-old son, Eric, was struck and killed by a texting driver. Eric was kind, gentle, and compassionate. He was also brilliant, athletic, and talented. His death was not only a loss to all of us who loved him so much, but to our community and the world. We needed him. Eric made the world a better place. He had just finished his first year at UC Berkeley, majoring in molecular biology, and was home for the summer. He was out training to join the Berkeley cycling team. He was riding his bicycle on a straight road in broad daylight. There were no visual obstructions. A 19-year-old hit him going 60 miles per hour. She didn't swerve or brake. He was hurled 140 feet to a violent death. Eric was doing everything right. The driver was sending and receiving text messages when he was struck and killed. Eric is but one of many innocent victims killed by irresponsible, reckless drivers using wireless communications while driving. The rate of killing by automobiles in California is 10 per day. That means in 1 year, 3,650 deaths are caused by distracted drivers. The number one distraction is using cell phones and texting behind the wheel. Texting is the deadliest. All the scientific studies prove that using a handheld cell phone while driving increases the risk of a crash by 4 times. This is equivalent to driving with a blood alcohol level of 0.08, the legal definition of intoxication. These scientific studies also prove that texting while driving increases the risk of a crash by 23 times. This is 6 times more dangerous than driving intoxicated. Our National Highway Safety and Transportation Administration says that 90% of Americans view impaired driving as a serious threat to the community and strongly endorse stricter and more severe penalties to protect themselves and their loved ones. Surveys indicate your California constituents feel the same. I have been trying to understand why any legislator would oppose increasing penalties for using handheld cell phones and texting while driving. These are the comments and reasons given to me by members of the Senate Transportation Committee. The current fine gets my attention. The ticket price may get the attention of a few, like the senator, but obviously it is not an effective deterrent for the majority of drivers. As Senator Smidian said, that initially after the ban, texting behind the wheel had decreased. Now it's doubled in 2011. Along with the explosion of texting, drivers have quickly learned the risk of being caught is low and the minimal citation cost is worth the risk. The current penalty minimizes the true danger and sends a message that it's not such a big deal. Parking illegally in a handicapped space, California has a base fine of $250, and after other fees are included, the first offense will cost over $1,000. This dollar amount has a significant deterring effect. The risk of the ticket is not worth the convenience. We already have a distracted driving law. We do not have anything that comes close to a distracted driving law. If the fine is increased, people can't afford to pay it. This response is illogical and nonsensical and irresponsible. The purpose of the penalty is to stop the behavior, not to enable the behavior. This is not a nuisance citation. We don't want to lower DUI penalties so drunk drivers can afford to pay the penalties. I find this view sickening. My son is dead because someone wanted to stay connected during an 8-minute drive to a friend's house, and the base fine for that illegal behavior is $20. This is just not right. This is a nanny law. This is not a nanny law, but a basic safety issue. Just like DUI laws, people can be as reckless as they want and make any poor decision they want when it does not endanger other human beings. No one has the right to drive on public roads while willfully engaging in activities that injure and kill people. It is wanton disregard for human life. If someone wants to play Russian roulette with their own life, that's fine, but it's not okay with others. Everyone on the road is at risk. People should understand this is not a matter of a nanny state gone bad. It is a matter of science, common sense, and life and death. Driving is not a right, and it certainly is not a constitutional right. My son's right to travel on the road without being slaughtered is the only individual right that was violated. All of you, as our elected lawmakers, have the power and the responsibility to ensure safety on our California highways. With your legislative decisions, you hold life in your hands. You are entrusted with this important task. All of these needless deaths and the implacable grief and the objectively sad, the observation of an English historian is fitting for this issue. Crime is not punished as an offense against God, but is prejudicial to society. There is no criminal activity more prejudicial to society than the toll taken by irresponsible drivers. The carnage on and along our roadways will continue until we significantly penalize the behind-the-wheel killers. Perhaps we have become desensitized to the highway holocaust. In any event, the loss of so many lives is grievously prejudicial to society. Our failure to respond is just as grievously prejudicial.
Thank you very much. Thank you. I really appreciate your courage in coming here and sharing that. Other witnesses in support?
Good afternoon, Madam Chair, members. Paula Liberty with AAA of Northern California. We are in support of the measure. We think that this fine brings it more in line with the egregiousness of this particular activity. The evidence is overwhelming that distracted driving of this nature is very, very dangerous, and so we think that the public will get a better message if the fine is a little bit higher because it's a little more consistent with the egregiousness of the act. So therefore, we urge your aye vote.
Thank you. Next witness.
Madam Chair, members of the committee, James Lombardo on behalf of the California Association of Bicycle Organizations, and we support the bill.
Thank you. Other witnesses in support?
My name is Jim Brown. I'm with the California Bicycle Coalition, and I can't tell you how many stories I hear like Eileen Okerblum's. And I'm one of those bicyclists who's out on the road and at risk of being hit by distracted drivers, and I urge your vote on this bill. Thank you.
Thank you.
Madam Chair, members, Eduardo Martinez on behalf of the Metropolitan Transportation Commission in support.
Thank you. Other witnesses in support? Witnesses in opposition? Comments from members? Cacho. Mr. Ashajian.
No, Cacho's fine. Thank you, Madam Chair. I appreciate, Mr. Smitty, your efforts bringing this forward. We need not to wait any longer. Need not to wait for another person to be killed on our roadways. If there is any opening to have co-authors on the assembly floor, I'd be more than happy to join you, sir.
Mr. Norby.
One can talk about serious offenses leading to serious consequences and why the penalties aren't steeper. and we could just raise penalties across the board for any one of a number of crimes, whether it's burglary or drunk driving or a lot of things, and make them steeper. And maybe we should do that. I don't know exactly where that would end. I think we try to go for proportionality in the original bills, and when we do raise them above the cost of living, there has to be some kind of justification for it. So I'm not sure what the justification is specifically here, other than just this offense can lead to horrible tragedies, as any offense can, and should we raise them on what basis? I'm not sure, but maybe the author would like to respond to that. The issue of fatalities connected with distracted drivers, certainly being distracted would be the leading cause of an accident. And distractions can occur in a number of different ways, but looking at the tie with cell phones, if the banning of the use of cell phones has directly led to reduction in fatalities, then seemingly when cell phones were first introduced, there was a consequent rise in fatalities. Maybe it happened. It's not borne out by the statistics. And if you look at it statistically, fatalities in terms of miles driven has been going down consistently, actually since the 1920s, mostly because drivers are better, roads are better, cars have more safety features. And so it's hard to pick out a specific thing that we may have had that may have led to a bump in fatalities, since overall they have been going down. So the issue of not being able to being fined if you're using a cell phone on your bicycle. Maybe the bicycle people would like to comment. I think they're mostly interested in a bicycle being in an unfair collision with a car. A bicycle distraction may be a danger to himself, maybe to a pedestrian as well. But that's there. So I have concerns about the nexus between just bumping these up, because I mean, $50, $100 if a tragedy strikes, Madam Chair. I mean, $100 seemingly wouldn't be much either. It ought to go up to maybe $5,000 or $1,000 or $10,000 or loss of a license. So maybe the author could address that, because I know you put a lot of thought into this.
I'll try and do it briefly, Madam Chair, because I know you've had a long day already.
Yes.
On the what's the basis to increase. When we started out in 2006, we had the most modest of base fines, $20. And I said at the time, my goal is not to raise revenue, my goal is to save lives. My hope was that that would be sufficient. And in many ways, I think it was a success story. As I said, if you can knock down both fatalities and collisions by 20% in the first year, that's a pretty good result. But here's the point. It is still a fraction of the $100 that is the typical fine for a vehicle code violation. I mentioned 3, littering, carpool lane, riding in the trunk of the car. So on the issue of proportionality, Assemblymember, I would say I think that a texting or cell phone distracted driving violation is at least half as important as a littering violation or a carpool violation or a riding in the trunk violation. That's the proportionality. And the purpose in increasing is to try and provide a more effective deterrent. That is the goal. Now, the question was, can we actually link the legislation to the results? And we can, and here's how we can. We looked at data going back 20 years, members, all the years for which we had month-to-month data from the CHP. There have been ups and downs over the years. Interestingly, the Public Policy Institute of California predicted we'd have 300 to 900 fewer fatalities based on the experience of 4 other jurisdictions that had already passed similar laws. Guess what? The 700 reduction was right in the zone that was predicted before the law took place. Equally important, that 20% reduction of 75,000 to 100,000 fewer collisions is important, because I thought, well, if we've got 700 fewer fatalities, that's 20%, maybe it's the click it or ticket, maybe it's the safer cars, maybe it's that people are wearing their seatbelts. But guess what? None of those things affect the number of collisions, do they? So the drop in the number of collisions was the same as the drop in the number of fatalities on a percentage basis. And that tells us people are bumping into each other less for some reason. Well, another thing we looked at was the CHP's annual data on how many folks, when they identify the source of the distraction that caused an accident, identified the handheld cell phone. And for years, since the beginning of 2001 all the way through the last decade, cell phones were the #1 cause of distracted driving accidents identified by drivers who had been in collisions. Guess what? That number dropped 50% for handheld cell phones in the first year following the new law in the books. So I think on proportionality, being still half of what the typical fine is not a stretch by any means. And I think we have a very direct nexus between the change in the law and the good results we've had here in California. With respect to bikes, the goal was to say bikes will be a $20 fine. Ordinarily, Assemblymember, bikes follow the same rules of the road as the rest of us, at least in theory, in the vehicle code. If the sign says stop, everybody's supposed to stop. If it says one way, bikes and cars are supposed to go one way. A drafting error, frankly, in 2006, when it made reference to motor vehicles following this law, accidentally excluded bicycles. We're simply coming back now trying to pick up bicycles, but with a more modest fee so that we don't impose an undue burden on folks who are cyclists. Yes, cyclists pose less of a risk, perhaps, than a vehicle, but if that cyclist swerves out in front of a car, that car then swerves and does damage to someone else's life or limb. And that's the basis for the law.
I do a lot of biking around the grid here. If I had to follow the rules of the road of the cars, I don't know if I'd survive. I'm talking about shortcuts, sidewalks, things like that, if I had to be out there with the cars. But that's a separate topic. The last question I had, Madam Chair, was if there was anybody here from the CHP, what their experience has been, if they have a position on the bill, and if they can find any direct correlations as have been represented.
Mr. Brown.
Good afternoon, Madam Chair and members. Captain Brown with the California Highway Patrol. We have an approved position on the bill. We're supportive of the bill. The data and information that Senator Simitian has quoted is accurate. The top three things that cause distracted driving, besides cell phone being number one, children number three, operating and using a CD and car player is number two. So his data is accurate and it is correct.
Thank you very much. Mr. Fortani?
No, my question's that.
Thank you. Ms. Buchanan?
I support the bill. I do have a couple of questions.
Thank you.
One is, have you factored in at all the higher percentage of people who have Bluetooth connections now with it seems to me that there was a time when everyone dialed and they held the phone up to their ear, and now virtually everybody, if you buy a car, the new cars, whether you have a Navi or not, have Bluetooth connections. So is that having an impact?
We think so. It's hard to get the kind of direct correlation that I felt confident giving Assemblymember Norby on the changing in technology. But in 2006, we deliberately delayed implementation of the law for a year and a half, not only so that the public would know and so that CHP and DMV would have time to update their web page and their handbook, but because we wanted to give time for the technology to follow the law. And over time, as you've referenced, the technology has gotten better and better. Bluetooth, of course, is going to be a cost issue for folks of modest means. So one of the things I like to remind folks is it can be a speakerphone, it can be a headset, it can even be the inexpensive little earbud that just comes with it, but we don't have a way to correlate directly the change in technology.
I just didn't know, if part of the drop was in addition to the fact that it's illegal now, had anything to do with the change in technology. And my other questions, the fine for bicyclists when you have the 20 or 50, is that all they pay, or does that fine get escalated?
Unlike the vehicle code fine for motor vehicles, which has other fees or penalties that get added on that make the cost of the ticket more significant, the cost of the ticket for the bicycle is just the $20 or $50 with no additional fines or penalties.
And what are you going to do with the 12 or 14-year-old kids? I mean, because we can assume that all your bicyclists are 16 or 18 and also have driver's licenses, but you also are going to have those kids that are driving to school, certainly in your community in which you live, the community in which I live.
And that was one of the arguments for saying, let's just make this a $20 ticket for a first offense. Again, the goal is to make it of record as a matter of law, that it is unsafe and a violation. The goal is not to raise revenue, as you'll hear on the next bill that I'm about to present. I personally don't think a ticket ever ought to be given as a revenue generator. That's my own view. So that's why it's $20 or $50 rather than with the additional costs of post.
Mr. Jeffries?
Yeah, I guess as one who would oppose fee increases sort of on the natural, for me anyways, I, however, view driving as a privilege. And it has incredible responsibilities. And because of my 29 years in the volunteer fire service, I have seen the most horrendous carnage one can imagine as the result of traffic accidents. I am extremely disappointed with legislation that has passed this year that makes it easier for DUI offenders to avoid checkpoints. I think that was a horrendous thing to do, but I believe this bill is on the right path because we do see incredible tragic accidents that occur because people abusing their privilege to drive on our public roads while using the phones. And look, I'm not going to cast stones. I can tell you many family and friends who've violated the law, and it has incredible consequences, as one of your speakers well knows. But people respond to their pocketbook being hit, hence the reason why I typically oppose taxes and fees. But this is an issue of privilege, and I think we have to communicate every method possible that this has serious consequences, and I think this is, and I hope this is, a step that will result in fewer accidents and fatalities. I'm a little concerned about the impact of bicyclists. Generally, when I see a bicycle accident, they crashed into a culvert or something, and most of them get up and walk. But when it comes to vehicles on the road, I support this bill, and I hope it does achieve what you and I both hope it achieves.
Thank you.
Mr. Logue?
Yeah, I also support the bill. I think it's a good bill. My concern is with the CHP. Do you have the ability and the resources to enforce something like this? My concern is overreaching and putting more burdens on you than you can handle. I'd rather have you pulling people over who are DUIs than pulling over bicyclists, but I understand the direction that you're heading in. So I will support it, but I just want to know your limited resources. Can you do this?
Yes, sir, we can. When the officer witnesses the violation, it's in his presence. The officer has the ability to take that action. DUIs, unsafe lane change, other type of erratic driving, yes, those are big ticket items that we focus on. But once we witness that violation, we have the ability to take it. We're not going to sway from that path of enforcing our duties, and no additional personnel is needed to do the right thing.
And I realize that, but I'm just thinking, I'm watching somebody riding down the street texting on their bicycle, and somebody's doing 90 miles an hour in an automobile. I just want to make sure that when they're writing tickets with somebody who's texting on a bicycle, it isn't taking them away from the duties on the freeway, which may be more hazardous. That's my only concern, but I will support it. I think it's a good bill, so thank you.
Ms. Bonilla?
I just wanted to point out the way it applies to those who are 18 and are under the age of 18, because I think that's a really important provision of the bill and one that I strongly support, and that is that it really includes texting now as something that would be considered primary, a primary offense. So many teenagers, and my youngest just graduated high school this past week, but they don't talk on the phone at all, ever. They're all texting. And so I just think that's one of the strongest provisions in here is the point that goes on the driving record, because we've talked a lot about the fees, but we haven't talked about the impacts on car insurance. And parents are very, very aware of what they're paying for their teenagers to drive cars. And having that point on there is something that I think could deliver a lot of consequences within a lot of homes of teenagers who need that encouragement to stop the texting while they're in the car. So thank you for including that, and I do support the bill.
Thank you.
Mr. Simidian, would you like to close?
Only to make two observations, Madam Chair. I appreciate very much the conversation we've had today because it shows a real change, I think, in understanding over the last decade. When the hands-free bill passed in 2006, during that year, 89 Californians were killed in the Iraq and Afghanistan wars, and we appropriately, in my view, mourned their passing. In that same year, 256 Californians lost their lives in fires, and of course, every one of those stories led the evening news. We worry about crime in our communities, appropriately so, in my view, and during that same year, 2,483 Californians were the victim of a homicide. But in that same year of 2006, 4,197 Californians died in traffic accidents. And for a long time, we just accepted that as something that was both acceptable and unavoidable. And the fact of the matter is, it's neither acceptable or unavoidable. And by taking the action that I hope you will today, we can prove that it is no longer acceptable and that it's not unavoidable. And it is for that reason that I ask for an aye vote.
Thank you very much. I, too, support the bill, Mr. Simidian. I appreciate your the support because of the way you came last year, and now you've enhanced it, moved it on with bicycles. So I think it's a critical public safety bill that will prevent the kinds of accidents that we heard about as we started this deliberation. And with that, could you call the roll, please?
Motions do pass to appropriations. Lowenthal?
Aye.
Lowenthal, aye. Jeffries?
Aye.
Jeffries, aye. Ashajian?
Aye.
Ashajian, aye. Blumenfield? Blumenfield, aye. Benia? Benia, aye. Buchanan? Buchanan, aye. Ing? Ing, aye. Furutani? Galgiani? Galgiani, aye. Logue? Logue, aye. Miller? Miller, no. Norby? Portantino? Solorio? Nine zero, the bill.
9-0, your bill is out?
9-1. I'm sorry.
9-1. 9-1.
Thank you, Madam Chair, and thank you, members.
Thank you. And now you're presenting Senate Bill 29.
Thank you. Madam Chair and members, we all listen to our constituents, and in my case, I had a constituent who entered an annual contest I have called There Ought to Be a Law, and she said, I have 4 or 5 red light camera tickets, and they're for a car that I don't own, have never driven, different model, different color, different license plate. And by the way, the car is 300 miles away in Southern California, and she lives in the San Francisco Bay Area. And she had to go through quite a series of hoops to untangle herself from citations which had absolutely nothing to do with her or her vehicle. And she said there ought to be a law, and I looked at the issue, and what I discovered was that the difficulty she was having was certainly not unique to her in terms of what happens when you get caught up in the red light camera bureaucracy, but it was also, frankly, just the tip of the iceberg in terms of the needed reforms to the red light camera law in California, which has just sort of grown organically over time. Now, I want to go back, if I may, to the comments that Assemblymember Jeffries made earlier about the importance of following the law and of saving lives. I do not for a moment discount the severity of running a red light. I want to be very clear on that. But if we're going to use a red light camera rather than an officer, we need to make sure that there are certain accuracy, due process, privacy protections in place. And I respectfully ask for an aye vote. 36-0, joint authored with Senator Huff. I believe Assemblymember Eng has asked to be added as a co-author at some point if possible, and we're happy to do that, Madam Chair.
Any comments from members? Mr. Eng?
Yeah, I think this is an important bill, and as someone who was wrongly accused of driving a car that had been garaged for about a year in another city 100 miles from my house, I think this bill is important. It brings accountability as well as safeguards the proper use of law enforcement tools to achieve traffic safety.
Mr. Blumenfield.
I'm going to support the bill as well.
There is an issue, though. I don't know if, one of the problems with the red light cameras right now is that the courts are not passing on the tickets to the DMV, and there's a lot of, these cameras should not be used for revenue, but the fact is the revenue is not ending up with the state or with the localities. I don't know if there's an opportunity as this bill moves along to try to help address that issue as well as the issues that you've put in here. But I'd like to see that also included in this bill if there's an opportunity to do that as this moves forward.
Thank you, sir.
Mr. Norby, and then Mr. Ashajian.
These are all put in by elected bodies, and the question would be, they're probably as responsive, if not more so, to the elected than we are, because they're directly responsible to them. All cities have responsible electorates. Well, there are a couple of cities actually that don't have electorates, one being Vernon. But other than that, maybe you answered my question. Why not trust their judgment rather than impose some kind of a state mandate on this?
There are two or three reasons, Assembly Member. The first is, under existing law, it is not unlawful to use red light cameras for revenue-raising purposes rather than for safety purposes. So a locally elected body has the prerogative under existing law to use these as fundraising tools rather than as safety measures. As I mentioned earlier, my own view is that tickets should never be given for revenue-raising purposes. That's why we try to make sure we don't have speed traps in California and around the state. But they are appropriate, in my view, and some folks just don't like the cameras altogether. My view is they're appropriate when there are safety considerations. So what the bill has done to address that is to say explicitly it is unlawful to do this for revenue-raising purposes, and if you want to install a new camera, we're not going back and undoing what's been done, then there have to be findings of fact by that responsible local governing body that there is in fact a safety issue in the community. And with that finding of fact, then the local governing body has the ability to move forward and put the camera in place. The second point I would make is that while we have local governments who are ultimately responsible, the problem is that we have 2 or 3 private sector vendors who are actually responsible for implementing the program. And so the responsible local governmental entity isn't the one actually always making the day-to-day decisions of how these things work. It's the contractor. And the goal here is to put some boundaries around both the local government and the contractor so that if they're going to use this tool and they think it's appropriate, they can do that, but with certain due process protections in place. So, for example, there has to be somebody who can actually pick up the phone and deal with the ticket if the ticket has clearly been misgiven. That's in the bill. Right now, that's not the case. For example, right now, people get what is euphemistically referred to as a courtesy notice that comes in the mail, and the very courteous courtesy notice says, Assemblymember Eng, it may not be you. It may be a 20-year-old Caucasian woman, and it may be rather clear that that's not you in the picture. But if you don't tell us who it is, then the citation goes to you. Mm-hmm. That is what comes on the quote courtesy notice. And my own view, Assembly Member, is that that's a clear violation of people's due process. To say that unless they are either both able and willing to identify someone else in the picture, that they get the ticket, that's inconsistent with our fundamental notions of fairness and due process.
Mr. Ashajian.
Thank you. And that's exactly what happened to me. It was my car, and I had to identify the person. So if hopefully this will become law sooner than later, can we go back at least a year and get the points removed off of our DMV?
For the record, that would be wrong,
Madam
Chair. No, no retroactivity. I'm sorry, Mr. Ashajian.
Any other comments? Would you like to close, Mr. Smitty?
Ask for an aye vote, and thank you again to the committee and the staff for help both last year and this.
Thank you for coming back with this, again, the new and revised version, and I certainly hope it passes this time. I know in Long Beach I've gotten a number of questions about where they're located, why they're located there, and so on. So this will take care of a lot of the problems that all of us experience with constituents who think that they are misplaced. So could you call the roll?
The motion's to pass appropriations. Lowenthal.
Aye.
Lowenthal, aye. Jeffries.
Aye.
Jeffries, aye. Ashajian.
Aye.
Ashajian, aye. Blumenfield. Blumenfield, aye. Benia. Benia, aye. Buchanan. Buchanan, aye. Ing. Ing, aye. Furutani. Galgiani. Galgiani, aye. Logue. Logue, aye. Miller. Miller, aye. Norby. Norby, aye. Portantino. Portantino, aye. Solorio. 12-0.
12-0. That's 2 out of 2, Mr. Smitty, and congratulations. Mr. Padilla.
Good afternoon, Madam Chair. Thank you, members of the committee. Before you is SB 642, which in some ways is a follow-up to SB 424 from last session that enjoyed tremendous bipartisan support, signed into law, and it updated the franchise agreements and relationships between auto dealers in the state with manufacturers, more in line with what is a de facto national standards. With the help of that bill and an economy that's showing signs of recovery, the vehicle market improved in the year 2010 for the first time in 5 years. And while the direction continues to go slowly in a direction for the better, number one, it's still slow, but number two, it's being threatened by new franchise agreements and clauses in agreements that in one way of looking at it circumvents the protection laws that SB 424 put in place. These clauses, these elements of agreements include those that force dealers to waive their rights by signing quote-unquote voluntary agreements that require dealers to waive statutory rights to protest their own termination. I don't believe this was the intent of the legislature or the understanding of the legislature. It certainly wasn't my intent as the author of SB 424. The bill before you would do a number of things, including, number one, prohibit a manufacturer from obtaining or enforcing any agreement with a dealer that modifies or disclaims any manufacturer obligations or waives dealer rights under California franchise laws. It would also prohibit manufacturers from obtaining or enforcing any agreement that requires a dealer to self-terminate. It would also prohibit manufacturers from discriminating against franchise dealers for selling non-approved or sponsored debt cancellation agreements, maintenance plans, and service contracts or similar products. My purpose of having this bill is to seek fairness for both manufacturers as well as the auto dealers. In addition, the bill would create a process for the independent review of these new vehicle franchise agreements and would prohibit the discrimination of dealers that refuse to enter overtly restrictive agreements. I know that in recent days the auto manufacturers have raised some concerns. Some suggested amendments, specifically those by General Motors, have actually already amended into the bill that's before you in print. Other concerns that they've raised, I believe, are much more appropriately addressed and discussed in the Judiciary Committee. Since this bill is dual referred, I prefer to do those there. But thus far, it's enjoyed unanimous bipartisan support. With me today is Brian Moss on behalf of the California New Car Dealers Association, Skip Dahm on behalf of the Recreational Vehicle Dealers Association, and Jim Lombard on behalf of the Motorcycle Dealers Association.
Move the bill.
Second.
First witness and support.
Madam Chair and members, Brian Moss with the California New Car Dealers Association. I want to thank Senator Padilla for helping us try to update vehicle franchise laws in California. As he described, the fundamental issue that we're trying to protect against is to strengthen an existing statute that bans the practice of dealers waiving their own rights. And what happens is manufacturers insist in these franchise and other side agreements that dealers waive their own right to protest their own termination. And the practice has been going on for a while, and it's accelerating. And we're afraid that what's going to happen is in a very short time, there will be no ability of dealers to protest before the New Motor Vehicle Board because manufacturers will require waivers in all agreements. I can give you chapter and verse of examples Fiat, Subaru, Nissan, Mazda, lots of manufacturers are requiring these self-termination clauses in agreements, and dealer has little recourse against a multinational vehicle manufacturer to say, oh, gee, I don't want to waive my rights, when they're asked to be doing something, whether it's upgrading a facility or what have you. So we think this protection is fundamental and updates an existing statute. There are other provisions of the bill. I'd be happy to go into those if there are any questions, but we've obviously spoken with many of you, and you know why we're sponsoring the bill, and we obviously ask for your support.
Thank you. Next witness in support.
Madam Chair, members of the committee, Jim Lombardo on behalf of the California Motorcycle Dealers Association, and we had a bill last year by Senator Berryhill that was addressing some of these concerns, and this is an even stronger bill, and we thank the senator for introducing it.
Thank you.
And Skip Dahm on behalf of the California RV Dealers Association. It really does restate and clarify and therefore strengthen the existing principles in fairness in dealing between manufacturers and dealers. We ask for your aye vote.
Thank you. Any other witnesses in support? Witnesses in opposition, please come forward. Can you make room for the witnesses? Thank you.
My name is Gene Urban. I'm here on behalf of the Alliance of Automobile Manufacturers. I'm in a slightly awkward position because it's my understanding the bill is going to be approved today by the committee and be referred to the Judiciary Committee, and serious conversations will commence as soon as 2 o'clock tomorrow in the conference room at the LOB. That's good. We'd love to have well-supervised, actively supervised discussions, because we just disagree with some of the characterizations. This is not a clarification of existing law. This is a wholesale revision of existing law. And I've promised to be sedate today because of the understanding about tomorrow's meeting. But I want to impress upon the members that we're very concerned. And yes, the bill moved out of the Senate 37-0 because we made a tactical error. We actually sat down and tried to negotiate with the sponsors. That was unsuccessful. We were chumps, apparently. But now we're opposed. We think it does 2 or 3 very important things that this committee needs to know about. You license automobile dealers. They sell very expensive equipment. They arrange financing for very expensive equipment. They have to clear title on used cars. They sell warranties. They service cars. They're licensed by the state of California, and you oversee that licensing process. They are now approaching you saying that they're unsophisticated and incapable of common commercial contracting. We don't think that's true. They've cited one case, this case, as the basis for the bill. This is a case in which the court labels the dealer's conduct duplicitous. And I can refer you to that. It's on page 15. Kyle, the dealer, waived its right to protest, then duplicitly protested. He received consideration for something, voluntarily agreed to a contract, and then did exactly what he said he would not do. Under this bill, as we read it right now, those contracts could still be entered into. The dealer could enforce it, but we couldn't. That, to me, is wrong. That's bad public policy. The bill also applies retroactively. By its own express terms, it applies retroactively. We don't know how to manage that. We don't understand it. We signed agreements in exchange for which dealers receive valuable consideration. It was voluntary in the truest sense of the word. And now those agreements can no longer be enforced by us. We don't understand it. The language of the bill says to obtain from a dealer or enforce against a dealer an agreement, et cetera, et cetera. Do they give us our money back? That's not in the bill. Lastly, the provision at the end of the bill pertaining to extended warranty contracts. I just want to take a minute. This is a major concern to us, and I think it should be to the committee. Every manufacturer provides a warranty when it sells a new car. They may last 3 years, 5 years, 7 years. Every manufacturer offers an extended warranty, so there's a seamless transition. Sometimes dealers sell warranty plans from non-original equipment manufacturers. We want the right to contract with those dealers when they're selling those plans to tell them that they're not from our guys. These are not a Ford. This is not a Ford warranty, a BMW warranty, a Toyota warranty. This is a non-OEM warranty. Don't come back to us and expect it to be fulfilled. We think that's a simple matter of contract that is also an important matter of public policy. Should that be disclosed, and should we have the right to negotiate that with our dealers? We think the answer is yes. Under this bill, we'd be prohibited from trying to negotiate that contractual disclosure. So we're eager to negotiate. We appreciate the purpose of the bill. We respect our dealers, but this is a very challenging proposal. And we would ask that these negotiations be very carefully superintended, and that at some point this bill come back to this committee so that you can fully concur in whatever is negotiated. Thank you.
Thank you, Mr. Urban. Next witness, please.
Madam Chair and members of the committee, I'm Tony Gonzalez, here on behalf of the Association of Global Automakers. We regretfully oppose SB 642 for many of the same reasons that Mr. Urban just articulated. I would like to just emphasize one point, that these are agreements that are negotiated between manufacturers and dealers. These are not analogous to, say, credit card agreements that a customer would get from a bank, where it is a truly take it or leave it proposition. You don't want the credit card, you don't sign the agreement. In this case, both sides are represented by counsel, and both have issues to put on the table, and we believe this is a tool for both that works for both sides to be able to negotiate terms that will work to resolve disputes if and when they rise in an equitable manner. I would say, lastly, the bill clearly does apply to current existing contracts which were negotiated and for which consideration was offered or given. We think it's inappropriate for legislation to reach back and rearrange the terms of existing contracts. And for those reasons, and I do want to mention, we do look forward to the discussions we're soon to have under the supervision of committee staff. But for those reasons, we do oppose the bill. Thank you.
Thank you very much. Are there anyone else in opposition? If not, comments from members? Ms. Buchanan.
You know, I understand the need for disclosure. I mean, if I'm buying an extended warranty, I want to know, is it really a Toyota extended warranty or a Ford, or and all of that. But I'm willing to vote for the bill today because I think the appropriate place to have these discussions is in the Judiciary Committee. I mean, I know that this is transportation because we're dealing with cars, but what we're really talking about is contractual obligations between two parties, and I think that the best place to work those out is the Judiciary Committee.
Thank you.
Mr. Ashaji.
Thank you, Madam Chair. Mr. Padilla, is there room that it can be disclosed if there's an extended warranty sold by the dealer to say that this is not a, let's say, Ford understanding, this is dealer off-market sales, that it's warranted and or honored in these garages or dealerships?
That, I think, is part of the substance of what's going to be discussed not only tomorrow but in Judiciary Committee, as far as disclosure of what the warranty offers should be. Separate from that, when offering a warranty or selling warranties, the level of detail of which garage is accepted, and because that can change over time as well, I think is slightly outside the four corners of the bill before us.
Okay. And for that reason, I'm wondering if it should have gone through that process first, then it's in front of us clear, we have a better understanding as what is the final bill going to look like?
I think the way I've shared with some of your colleagues on this committee is the bill is dual referred to both transportation and judiciary. How it works in this House about which committee it goes to first and which one goes to second, I'm not familiar with. I have headaches of my own in my own house when it comes to bills that are dual referred, but I believe that the process is intended to resolve transportation policy questions and issues in this committee and the judiciary policy questions and concerns in that committee. So if there's a specific transportation policy or question, I'm happy to consider that.
Thank you. My concern, Madam Chair, that if something moves forward with a manufacturer's logo on it, it's understood by the person purchasing a vehicle that this is good at all manufacturers' locations, and I want to be sure that that doesn't make an unhappy customer, which is a reflection on the manufacturer. That's my only concern here. Otherwise, I'm supportive of the smaller business person than the bigger retailers. So,
Mr. Oshachi, and I think Mr. Moss can respond to that.
Okay.
I wanted to kind of clarify the issue. The provisions in the bill deal with extended service contracts, not warranties, and similar agreements, GAP and other agreements. And the question that we're trying to resolve with the legislation and that Mr. Padilla has put forward is whether or not manufacturers can discriminate against dealers who refuse to sell manufacturer-sponsored agreements. And what the manufacturers have asked for in their amendment is some kind of disclosure that a dealer would have to give to a consumer that says this isn't a manufacturer-sponsored agreement. We think that disclosure in and of itself is further discrimination against the dealer's ability to sell non-factory sponsored agreements. There are many insurance company sponsored service contracts and others that are offered by independent third parties that dealers may choose to sell, particularly if it's a used car that isn't of the model or make of the manufacturer for which the dealer represents. For example, a Ford dealer may sell a used Honda, but that doesn't necessarily mean a Ford service contract is the best one for that particular consumer. So that really is the issue that we're going to obviously be discussing in the negotiations going forward, and I just wanted to clarify the parameters of it.
So in other words, if I'm buying a used car and the dealer is giving me a service, whatever you want to call it, somehow what I buy, what I sign for, I'll have the understanding that this is an offer from a dealer or off-market service, extended service, that it's only good in so many places, because just because I bought that from a dealership who's under a Ford logo, let's say, doesn't mean that I can go to another town to a Ford dealership and expect them to honor that extended services.
It would obviously depend directly on what the service contract specifically provides for, and that's going to vary by vendor, by dealer, what have you, and it certainly would be the obligation as from the dealer's perspective to explain to the consumer what's in the contract, and obviously from the consumer's perspective to know for sure what they're buying.
And that's what I want to hear, that there will be a way to explain to the consumer what are they purchasing.
And there's already some requirements on the books.
Thank you.
Ms. Buchanan.
I've been in that situation, and if you don't know the right question, you don't get an answer. So I'm like I said, I'm willing to vote for this bill, but I do think it's important. If I'm buying an extended warranty, I want to know, the consumer is going to think they've got a 3-year warranty with the car. They're going to get 7 years coverage, and that's going to be, they're extending their warranty 7 years, and they want, or 4 years out to 7. Don't you think the consumer, there should be some disclosure so the consumer knows? I don't think you should be restricted to selling any one warranty, but some disclosure so the consumer understands.
The difference.
Because I don't think, otherwise there's an assumption there, and you don't want to go visit your relatives, for me in Idaho, and all of a sudden find out that no, it's really not a warranty, or I've got to put out all this money up front and then submit a claim and get reimbursed. I mean, I just think disclosure is an honest thing to do with the public.
Mr. Norby.
I'm inclined to pass this on to the judiciary. Even the opponents have a figure that's where it's going to go, and that's will be hammered out. But Mr. Urban specifically had a compelling testimony regarding the appearance that this is consumer protection for the dealers against the big bad automakers, and that they're not sophisticated enough to enter into these contracts in the first place. Is that accurate, or how would you respond to that?
I'd respond a few ways. California's had a waiver statute prohibiting waivers on the books for several years. It's a question of how broadly that statute should be interpreted. That's the question for you, elected representatives, to ultimately decide. Several other states have anti-waiver provisions. I just researched today. Texas's anti-waiver provision is as clear as could possibly be. An agreement to waive the terms of this chapter is void and unenforceable. Lots of states have these. So this is not new or different or what have you, and there's a reason why states all across the country have a series of franchise laws to protect dealers, the state that collects sales tax revenue, and ultimately consumers. And it's because, notwithstanding Mr. Urban's arguments, there is disparate bargaining power between manufacturers and dealers, not just new car dealers, but motorcycle dealers and RV dealers. And if we don't protect dealers, in some cases against themselves, we will run the risk of a disorderly market, no place to service your vehicle, manufacturers deciding they want more than one dealership to be located in a relevant market area, or no dealerships to be located in a relevant market area. That's why these statutes exist. And the policy question for the legislature is to decide what is or should be fair.
I think one of the fundamental ways of looking at it is let me not use a car manufacturer or dealer example. I'll jump to motorcycles for a second. If you're Harley-Davidson, the manufacturer, odds are multiple markets in California, you're going to have more than one person interested in being the Harley-Davidson dealer. If you're a Harley-Davidson dealer, it's kind of hard to sell Harley-Davidson without the manufacturer supplying the Harley-Davidsons. So they do come to the negotiation table prepared, professional, et cetera, but from slightly different positions.
Mr. Jeffries.
I've met and listened to the opposing parties on both sides of this, and I trust and respect both opposing parties and find their arguments extremely credible on both sides. And so I have sympathies towards the issue of the extended service warranty, and I think we heard some questioning along that line where consumers should see who they're buying it from, who is providing it. If it's not the dealer, if it's not the manufacturer, I think the consumer needs to know that. I have concerns about the retroactive applications and what does that mean exactly. But at the end of the day, we're being asked to resolve contract law. We're being asked to resolve a dispute or an interpretation of contract law issues. I don't believe that I or some of my colleagues perhaps feel comfortable doing that. We're not prepared to dive into the line-by-line issues of what some of these issues, what some of the ramifications of these would be for either the dealers, who I trust and respect, or the manufacturers. If we had the ability to send this bill to the Judiciary Committee without prejudice and tell them, send it back when you've done and you've figured it out, I'd do that in a heartbeat. I'm not prepared today to render a decision on some of these disputes over contract law. They need to be resolved. And I am hopeful that the meeting tomorrow will be conducted by both parties in very good faith to try and do what's right for the consumer, try to do what's right to protect the manufacturers and their product, and respect the dealers who have very difficult time dealing with manufacturers who are, in fact, can be in some instances, certainly not all, very heavy-handed in their dealings with their franchisees. So I am not going to vote on this today. I'm going to reserve my right to vote on this when it either comes back to committee or, if it doesn't, when it comes to the floor. But I just want both parties to please resolve this. Don't look for this body to try and resolve your contractual disputes. Even though we're elected to do these things, I understand the argument. But we have two industry giants here who need to figure this out and come back to us with an agreed-upon solution as best they can, as best they can.
If I could just say, I do appreciate that, Mr. Jeffries, which is why I called last week after meeting with both sides for a mediation, which I think will be very effective. I also spoke with Mr. Fuhrer. He's really happy that his committee will have a chance to work on that mediation, and his staff along with mine. Because, as you said, I think we're not in a position, or at least I can say for one that I'm not, in understanding the nuances of contract law, the retroactivity of laws that could be passed. So with an understanding that if we move this forward today, which I am recommending, your vote does not mean that when it comes back to the floor, you're obligated to vote in any way. I want to move it forward in order to have that mediation and be heard by judiciary. And so that's the recommendation that I'm going to make. And did we have a motion or no? And we did have a motion to do just that. Would you like to close, Mr. Padilla?
Madam Chair.
Okay. Yes, Mr. Logue.
Thank you. I agree with your statement, and my concern is that we don't move this forward. It's never going to get resolved. So I'm in the middle of this issue, but I think it's crucial that we do move it forward in order to resolve the issue. So I'll vote for it so we can bring it back and find out what we end up with.
Thank you. Would you like to close?
Okay. Yes, thank you, Madam Chair. Thank you to the committee for good questions and discussion. A couple of things. Debating whether or not to say the following, but I'm going to choose to say it. Gene Urban is not a chump. Around the building, some people say he's a slightly better than average lobbyist, a little bit more than half the time. My personal experience with him is that he's much better than that on behalf of his clients. So I want to state that for the record. As a matter of process, I do believe Mr. Urban said that there's finally going to be serious conversations that begin tomorrow at 2 o'clock. I do have to differ from that a little bit. This bill was introduced on February 18th. February 18th, this bill was put across the desk. So issues, questions, concerns that have come up in this last week are not, there's been ample time for questions and concerns that have been raised. In fact, they have been raised along the way. Numerous attempts at discussions, meetings, resolution, and they're kind of escalating to this point of mediation with your staff, Madam Chair, tomorrow at 2. But by no means is this the first attempt at conversation or resolution to some of the outstanding issues. I would note, as your committee analysis recognizes, not only were some of the questions and concerns raised, but Senate Judiciary Committee passed this item unanimously, came off of the Senate floor with overwhelming bipartisan support. Not that we've finished with the work before us, but clearly I believe that is significant to mention here in the close. Appreciate your consideration today, and we'll report back to committee the outcome of mediation and Judiciary Committee.
Thank you very much. The motion is to move the bill to Judiciary. Is that correct? Is that the correct?
Yes, do pass to Judiciary.
Could you call the roll?
Lowenthal?
Aye.
Lowenthal, aye. Jeffries?
I'm off.
Ashajian?
Understanding the process, yes.
Ashajian, aye. Blumenfield? Aye. Blumenfield, aye. Bonilla? Aye. Bonilla, aye. Buchanan? Aye. Buchanan, aye. Ing? Aye. Ing, aye. Furutani? Aye. Furutani, aye. Galgiani? Logue? Logue, aye. Miller? Abstain. Norby? Norby, aye. Portantino? Solorio? Solorio, aye. 10-0. The bill's out.
10-0, your bill is out. Thank you. Okay, we're going to leave the roll open?
No.
What do we have? And that's it?
Yeah.
Thank you, members. We're going to leave the roll open for add-ons.